right, so next up, we are delighted to have 4 individuals who participated directly in the 1967 Commission return to discuss their experiences and perspectives. The conversation this afternoon will be moderated by Dean Alan Morrison, who is the Lerner Family Associate Dean for Public Interest and Public Service here at the George Washington Law School, where he teaches civil procedure and constitutional law. Dean Morrison has also been an assistant United States attorney in New York and spent most of his career working for the Public Citizen Litigation Group, which he co-founded with Ralph Nader in 1972. His work there involved a wide range of subjects in law reform litigation, including improving access to justice and making legal services more affordable and available to everyone. Additionally, Dean Morrison is a member of the American Academy of Appellate Lawyers and was its president between 1999 and 2000. He has argued 20 cases in the United States Supreme Court and continues to file amicus briefs and assist lawyers in preparation for oral arguments there. And he is going to introduce us to our slate of panelists this afternoon. Please enjoy.
Thank you, Kate. I hadn't thought about saying this, but I probably should disclose that I was the lawyer who unsuccessfully challenged the first round of sentencing guidelines of the Supreme Court, managed to lose 8-1, getting only Justice Scalia, who referred to the sentencing guidelines, which were mandatory at the time, the Sentencing Commission acting as a junior varsity Congress. Eventually, that got straightened out by making them advisory, not mandatory. So anyway. As Judge Saris has indicated, in July 23, 1965, President Johnson signed the executive order establishing the Commission on Law Enforcement and Administration of Justice. It was chaired by Deputy Attorney General Nicholas Katzenbach. It issued a 300-page report, a copy of which I have here, in February 1965, with 200 specific recommendations. And to be clear, although it was a federal entity, it made recommendations that applied across the board to states as well as the federal government. And while Judge Saris obviously had jurisdiction only over the federal sentencing guidelines, the recommendations applied to states as well, where most of the criminal law enforcement is brought in the country. We have 4 very distinguished panelists here today, 3 members of the staff of the commission, and 1, Judge Wald, who was on the companion D.C. commission, but is very much involved in the issues then. And so let me give you a little background about all of them now. Judge Wald served as a judge of the United States Court of Appeals for the District of Columbia Circuit from 1979 to 1999, and she was the chief judge from 1986 to 1991. In the mid-1990s, she was a member of the American Bar Association's Central and Eastern European Initiative, where she worked on constitutional and judicial reform. In 1999, Judge Wald was appointed by UN Secretary General Kofi Annan to serve as a justice on the International Criminal Tribunal for the former Yugoslavia. Judge Wald has served on numerous advisory boards and, most significantly, in my judgment, in 2013, she was a recipient of the President's Medal of Freedom. Continuing down the road, next is Sheldon Krantz. He currently serves as a visiting professor of law at Georgetown Law Center and as co-director of the Justice Lab. Prior to serving that capacity, Professor Krantz was the director of the D.C. Affordable Law Firm, a charitable nonprofit created by Georgetown Law Center, DLA Piper, and Aaron Fox to provide low-income legal services to D.C. residents. Prior to his current position, Professor Krantz was a litigation partner at DLA Piper and director of New Perimeter, a global pro bono affiliate. He was a federal prosecutor with the Department of Justice and served as a staff attorney for the Presidential Crime Commission, subject of today's talk, and the director of the Massachusetts Criminal Justice Planning Agency and the dean of the University of San Diego Law School. He is also a former chair of the American Bar Association Criminal Justice Section. Next is Professor Elizabeth Bartholet. Betsy, as she's known, is the Morris Wasserstein Professor of Law, Public Interest Professor of Law at Harvard Law School and faculty director of the Child Advocacy Program, which she founded in 2004. She teaches civil rights and family law, specializing in child welfare, adoption, and reproductive technology. Before joining the Harvard faculty, she was engaged in civil rights and public interest work, first with the NAACP Legal Defense and Education Fund, and later as founder and director of the Legal Action Center, a nonprofit organization in New York City focused on criminal justice and substance abuse matters. And she was a staff member of the commission, about which we'll hear more in a minute. And finally, we have Susan Freeman Shapiro. She served as a member of the staff of the commission, where she focused on areas of juvenile delinquency, youth crime, and served as a special assistant to the executive director. Previously, she was a staff member of the Office of Criminal Justice in U.S. Department of Justice and worked on the American Law Institute's Pre-Arraignment Procedures Project. Following her work on the National Commission, she was a staff attorney and then managing attorney with the District of Columbia Neighborhood Legal Services Program and a partner in the nonprofit law firm of Roisman, Shapiro, and Reno. In preparation for today's program, we're going to divide it into three parts. First, we're going to look back at what the commission was like back then. And we're asking each of the panel members to talk to us about how they saw the commission's task. What were the fears or concerns that led to the animation of the commission? What were the goals of the commission overall, and from your individual perspective? Were there issues that seemed big then, but were not big now? On the other hand, were the issues that the commission missed or misread that we feel differently about today? And the report, while very detailed with 200-plus recommendations, it did create an overall impression in your mind. And so I've given these general topics to the panel members, and I've asked them also to give a little bit of background on how they got on the commission and why you decided to take a position on the commission. In doing this, we recognized that there were 19 commissioners, 63 staff members, 179 consultants, and hundreds of other advisors. And so each of our panel members can give only the impression from their perspective. So we're going to proceed now with this part of the discussion. And Betsy Bartholet, could you begin? We'll proceed in alphabetical order. Betsy, Sheldon, Susan, and then Judge.
Okay. So first, I want to thank the Law Review for organizing this symposium, and I guess it's a good thing to have been stimulated to try to figure out if I could remember anything from 50 years ago, and answer any of these kinds of questions that Alan asked that we think about. It also was an extremely interesting experience that you stimulated me to do, to reread something that I wrote 50 years ago, which I hadn't read since. And I was pleased to find that I actually agreed with pretty much everything I had to say back 50 years ago. So,
which part of the report did you
I rewrote a bunch of it, but I specifically wrote a chapter that I'll talk about a little later, which was a chapter in a task force report. So Judge Saras really didn't do her job. She only read the commission report, apparently, but there were several. She could have read thousands of pages, and certainly should have read my chapter on something I'll talk about a bit later. So Alan threw out a bunch of questions just now, and some on the telephone, but I had the impression that we each only had a few minutes. So I'm going to focus on some of the questions, and certainly willing to try to answer more if you suggest that I do so now or later. First, I wanted to say that in trying to think about talking today about this commission report, I thought about the title, The Challenge, which I remember fighting Jim Vorenberg about, the challenge of crime in a free society. And I can't remember what I thought was wrong with it, but I thought it was too wordy or too whatever. And then in talking to you on the phone, you were sort of pushing me to think about what were our goals and sort of what did we accomplish. And given much that I think that happened just the opposite of what we might have hoped and recommended, the way things should go, I was thinking of how when I teach my students, because over the years that I've taught, I've been teaching at Harvard Law School since 1977, and I've largely taught, not only, but largely taught law and social change courses, even if it's employment discrimination or child and youth reform work. I'm very interested in teaching students who care about going out and doing law and social change. And so I was thinking the challenge of crime. Well, I was thinking in terms of this talk about the challenge of law reform and how part of what I tell my students is, you know, when you're young, you think, well, yeah, you can get on this commission. I mean, why did I get on it? Because we were going to change the world, and I cared about criminal justice, and we would write this report and do criminal justice reform. And what you learn after years of doing law reform, social change work is either you give up, which I don't think you should, or you get a little more modest and think, well, it's really hard to do this work. It's hard to change the world. The world is the way it is for a lot of reasons. And changing it to try to create basically more justice for the people who don't have it, well, there's a reason they don't have it. It's hard to do. And then the second major thing I say to students is, well, it's better to challenge injustice than not to do anything about it. So it's hard to accomplish change, but it's worth trying. And we did try. And so when I think of the goals, I was going to try to talk a little about the goals, what we thought we were trying to do, and then a little about the accomplishments or lack thereof. In terms of the goals, and it is 50 years ago, but my sense of what most all of us, and there were a lot of people, but the ones I knew, including Susan in the same office, I think we all were part of, or for the most part, the commission staff and commission itself were part of a progressive 60s mentality. I think we, as we approached the task of the commission and the report, had certain values that, as I remember, one was we believed in rationality. I mean, Jim Vorenberg was my professor at the law school. He came from the faculty of the Harvard Law School. He was executive director. It was a very intellectual enterprise. We believed that if you applied your minds, and if good minds were applied to the task of figuring out what was wrong with the crime picture, what was wrong with the criminal justice system, we could improve upon it. So there was rationality. We had a set of what I would call classic 60s progressive values. I think we believed in being humane, if you will. We were concerned with the poor people. We were concerned with not just the victims of crime, but the perpetrators, and we saw them as victims, and we were very concerned with the conditions that produced crime, and we were concerned with helping people who had committed crime get rehabilitated, get diverted if possible, not be treated in the most coercive, punitive ways. If they had to go into prisons, we were concerned with having prisons be rehabilitative so that these people could come out and have a chance to become members of society. I mean, we also thought this was in the rational self-interest of society to have people who committed crimes be given a chance to stop doing it, since most of them, as Judge Saras pointed out, were not going to be in prison forever. They were going to come out. I think one of the questions that came up when Alan and I talked on the phone was, and I felt the skepticism as he was asking the questions at least, was, were we sort of politically savvy enough? We had these, dozens on dozens of recommendations. Were we politically aware? Did we think of how to make our report actually be effective? So I was reminded, as I thought about whether we were politically savvy, of some political savviness that I thought was exhibited by our executive director, Jim Vorenberg, at least as compared to my naive self. This was my second job out of law school, and I'd only been 1 year out of law school when I started at the Crime Commission. So one thing I remember was being exposed to the reality of the power of FBI Director J. Edgar Hoover. So on this issue, one of the issues, there was an assessment task force and report, and one of the issues was just how much crime is there? And is it going up? And if so, what kinds of crime are going up? And how serious is what's going up? And my memory, it may be a little different from what Judge Sarah says is reality. I do worry about my memory here. But my memory is that the people, very serious people on the commission staff who were trying to figure out just how much crime there was and how serious it was, that their sense was it wasn't as much and as serious and going up as much as people feared it was, that the fear factor was greater than the amount of crime. However, we learned that FBI Director J. Edgar Hoover thought it was really important that crime was going up and that very serious crime was going up. And I thought, so what? I mean, our job is to find out how much crime there is and report accurately. And it turned out that I think Jim Wernberg and others that mattered thought what J. Edgar Hoover thought was incredibly important, that we had to pay a lot of attention to it. Now, I don't remember that we actually tailored what we said about the amount of crime to suit him, but we were very concerned about the politics of that issue. The other thing that jumped to mind when you asked if we were politically attuned enough was I was in charge of not only writing one chapter and rewriting some other stuff, but the other thing I remember, which was really, really fun, was being in charge of photographs for the primary report. And so there were the police section and correction section, and in the police section, I had some photos I'd picked out of various places, I don't know, that you find photos that involve police not always doing the right thing, and sometimes also having their jackets not always buttoned up. And I learned from the police that they only wanted photographs of them helping old ladies across the street and other beneficent things. And also, their jackets always had to be buttoned up. And I suspect that if we looked at the police photos in the Crime Commission report, they got their way. And I don't think there was like police violence or any unsavory thing there.
Okay.
So, yeah.
Sheldon.
Well, I thought about the commission during the election last fall because Trump, as you may remember, one of his major themes was fear of crime. And it took me back to the 1960s, and even though he was terribly unsuccessful in running for president, Barry Goldwater actually set the tone in the 1960s by talking about fear of crime. And he made the comment about the growing menace in our society. And President Lyndon Johnson was not actively engaged on the issue, but I think Barry Goldwater forced him into it. So in March of 1965, he decided, using some of Barry Goldwater's language actually in his message to Congress, that crime had become a malignant enemy and that he needed to create a commission. There were some, I think, very positive goals at the time when the commission was created. The first that was mentioned was a lack of understanding about the causes and growth of crime and the need really to make a more systematic analysis of it. In the 60s, there was literally no federal role in state and local law enforcement, and so another question was, what should the federal role be dealing with crime? In the 1960s, I think it's fair to say that policing was in a somewhat primitive state, and in Johnson's message to Congress, he emphasized how important it was to upgrade the police. He also mentioned something at the time that was really important, less important now, and that was organized crime. There was great fear of organized crime in the 1960s, and so he highlighted that. A couple of other things that he highlighted, Judge Sarris talked about one of them, great emphasis on the drug problem, and interestingly, a great emphasis on the need for gun control. And so those were some of the messages that we got when the staff was assembled. And Alan has asked us to think a little bit about what were the issues that were big then that do no longer seem as big. And I think one is there was basically no real good data on crime and the system of criminal justice. And I think it's fair to say when you look at accomplishments going back to the 1960s and thinking about now, is we have an enormous amount of data now on crime and on whether the system is working or not. So I think that was an important issue. In the 1960s, there was the concern about lack of basic equipment for law enforcement. And I think we've come a long way there. There's some questions about whether we've come too far. And with respect to some of the issues that what did the commission miss, because there was 200 recommendations and we covered a lot of ground, I think we did deal with a lot of issues, but it was interesting. The primary focus was on stranger-to-stranger crime, and we did not deal with issues like interfamily offenses, domestic violence. As a matter of fact, if you look at the commission report, women as a part of our society is strangely absent. There was
from not just from the defendants, some in victims, police, certainly never mentioned in the police.
Well, that's right.
Prosecutors.
Yeah, I mean, basically, that's right. The lack of women throughout the criminal justice process was really not focused on. I mean, there was some discussion
One
of
other
diversity.
thing, footnote I'd add to that, which struck me, was that if you look at the language
Yes.
in the main recommendations, it will be every American and his right to an opportunity, et cetera. And you'll find that throughout. We hadn't graduated to the
Right.
non.
And actually,
gender
yeah,
form of
and it's
language.
interesting because the staff was primarily made up of extremely bright women, including the two to my left. But somehow that was not a real focus of the report. Alan also asked, how did we get involved in the commission? Why would we have decided to do this kind of work? Before I came to the commission, I was a federal prosecutor in organized crime and racketeering. As Alan mentioned, I left to go into private practice, went back to Omaha, Nebraska, my home, and got a call from Henry Ruth, who's the deputy director of the commission, and his comment was interesting. He said that the staff had been organized. The police staff was largely made up of police officials who were at one far corner of our offices, and the police were extremely isolated from everybody else, and there was virtually no interaction. And so he asked, as my charge, if I could come back and see if we could somehow better integrate the police with the rest of society. So that was the task, and it was actually one I enjoyed undertaking.
Sheldon's going to talk a little bit about policing in a minute. Did you have a, Pat, did you have?
No.
Oh. Susan?
Yes, thank you, Dean Morrison. Hello. And thanks so much to the law school and the law review for this memory-stretching opportunity. I like so much what my colleagues have been saying about the issues and the larger parts of the commission. Let me just talk for a minute about a couple of more personal of Dean Morrison's questions. I had come to Washington a few years earlier to work for the Office of Criminal Justice, which was a little 6-person unit that had just been created in the Deputy Attorney General's office of the Department of Justice when Attorney General Robert Kennedy became aware of the great unfairness and the unnecessary cost of the money bail system and thought that that should be improved, and perhaps there were other aspects of the federal criminal justice system that should be looked at. So we were merrily looking at all sorts of things when along came the Crime Commission. And of course, the Office of Criminal Justice had already been heady stuff just the kind of thing that a young lawyer comes to Washington to do. And here was an opportunity to go and work for this new and unknown but exciting sounding crime commission. Why not? I was in. It's a little bit amusing and perhaps visually a little bit misleading that of the four of us up here, three of us are women, because as has other aspects of which have just been suggested, that's certainly not what the landscape looked like at the commission. There were 2 women total on the commission itself. There were no women directors or heads of specific task forces, except for the clerical staff and secretarial staff. There were really very few women on the staff. And most striking, if you look at the pages and pages and pages of consultants in many different fields all over the country, to say that there was a sprinkling of women would be an exaggeration. Personally, I didn't feel uncomfortable at the commission, unlike some other experiences that I had. I didn't feel uncomfortable at the commission with this situation. I felt a lot of collegiality, a lot of mutual support, a lot of feeling that we were in this together and we were interested in each other's work. And the truth is that as far as we women were concerned, that's really what we were used to in those days, because there were so few women lawyers and so few women in law school. A quick story just to elaborate on that point. I am a member of the class of 1963 at Harvard, which I believe was one of the last of the major law schools to admit women. I think they let women in 1950, so that you can see that by the early 60s, they were still struggling to get used to having us there. Some of us lived in a residence house that housed a variety of women in graduate programs. And one Sunday, we invited all of our deans to tea. And the law school dean, to his credit, did show up. And I asked him why there were so few of us. And he assured me with all apparent earnestness that they were working hard, as he put it, to find qualified women. So I think I would have found this a peculiar statement under any circumstances. Having just spent 4 years at a women's college, I was really quite baffled. Thank you.
Judge Wald.
Oh, there's one more thing that I would like to say, Dean Morrison, if I may, picking up on Betsy's point about change. I want to say to any of you out there who are thinking of going into this field, yes, you really do need staying power. And to those of you who are in the field, thank goodness that you are showing the staying power that you are. Of course, there are challenges in all fields of human endeavor. This seems to be one in which particularly you have to be prepared for the experience that you think you've worked on something and even maybe improved it and made a difference. And eventually you discover that it's time to start all over again. We have a really good example of that these days. We're hearing a lot about people's concerns about the money bail system, the unfairness of it to people who don't have money, the unnecessary cost to the system. And when I hear that, I think back to even before the Crime Commission, if you can believe that, when I first met Judge Wald, who wasn't Judge Wald yet, who was working on trying to figure out how to make the federal bail system more fair.
Okay, that's a great intro. Thank you. I have a slightly different relationship with the National Crime Commission. Actually, I was only a consultant to them. I wrote 2 papers for them, one on the role of poverty in the criminal justice system, and the other on the role of civil society and non-governmental operations on it. But I was a full-fledged member of the DC Crime Commission. Now, it's interesting because President Johnson he appointed simultaneously a DC Crime Commission at the same time, and it operated on the same timelines and basically covered the same kinds of subject matter as the National Crime Commission. Why? Well, I think the best answer I have is that DC, where I had lived since the early 50s, as it were. I came down to Washington in the early 50s. I had gone to Yale Law School, which had been admitting women since 1915.
All right.
And on the other hand, I also was in the generation when, after law school, and I worked for a year with a law firm here in Washington, Arnold Porter, again, the only woman, obviously. But I then took 10 years off to help raise my 5 children. So when I tried to come back into the profession, I was not only a woman, but I was a woman who had been out of the profession for 10 years. And I did manage to get strangely enough, a consultant job in that Office of Criminal Justice with Dan Freed, who was running it, then had been a former law school classmate. So I wrote, my first job was to look at the bail system in the United States, and I wrote something called Bail in the United States for a national bail conference. After that, they were setting up legal services, and I wrote the conference publication for the Conference on Law and Poverty. And I think on the basis of those was probably how some nice people suggested I be appointed to the DC Crime Commission. More important, why did there need to be a DC Crime Commission? Well, let me just tell you as an outsider from the inside things in the National Crime Commission what it looked like to me, and I'll try to be very quick here.
So we have lots of time.
In the late 60s, which this was a very divided country, just as it is a very divided country now. Those of you who have been watching the Ken Burns Vietnam series know how divided we were and what a problem that was for President Johnson, because he not only was trying to, I think, extricate us from the war, but on the other hand, as the series showed, actual clips, he was saying, there's an election coming up in a year, in 1968. Well, inside the country, you had somewhat the same problems he had with a growing, 2 things were going on in the country. There was indeed, the crime rate was high. It was much higher then than it is now, incidentally. But also, you'd had beginning of a general feeling that we didn't have enough law and order, which was ultimately the platform on which Richard Nixon won the election that Johnson did not run for in the final analysis within a year. You also had, within a year, the race riots in all of the major cities, which were coming up. But even then, there was a lot of mixed feeling about student protests, because you had the students rebelling not just against the Vietnam War, but against authority in their own institutions. You had protests all over the place. So there was a general feeling, I think, with the high crime rate and all of this unrest and rebellion, that you had to do something. And I think that was one of the instigators for Johnson to come down with the Crime Commission. I know that in DC, for instance, just to bring it down to the home town, the Evening Star, which was one of our 2 major papers, ran something called the Crime Clock. And it ran it every night, or every day. It was an evening paper. and they would show you every crime on the crime clock going around there. It was called, DC was called the crime capital of the world. And so there was particular feeling, I think, that something had to be done about DC. It was the capital of the United States and of this terrible crime, and that's why a whole separate commission. But we also, in DC, had a lot of problems. We had all over the papers, the juvenile court was split between two judges. There were three judges, but the one judge was a more traditional judge, espousing the social work concept of the juvenile court, which had started out being a place where you brought the children and they'd be taken care of with a wise, paternal it was then, paternal look at them, when actually the conditions were really quite different. And there was a civil rights-oriented judge, another Yale Law School graduate, who wanted them to have legal rights. And remember, we didn't yet have Galt. And so, as a matter of fact, I attribute Galt in great part, if you read it, Abe Fortas actually came to us and got a lot of the material that we had done in the DC Crime Commission, and the National Crime Commission had done more, but also adopted a lot of the ones we had about what was really happening in the juvenile courts. So that was one problem. The other thing was allegations by the ACLU and others of police brutality here in DC. So these, I think, were the reasons. I only want to make two last points about it. So you had all of this unhappiness or division, unrest going on in the country, and especially in DC. But something that Betsy brought up, which I think was true, was there was still, at the opposite end, a kind of optimism or a kind of belief that if you really sat down and thought about it, and you really could come up with some solutions. And I think part of that went back to the fact that, remember, in the early part of the 60s, this was the 60s not just of unrest, but it was the 60s in which minorities, especially the civil rights advances of the early part of the 60s, but those, and you had women coming to the fore in the women's movement, you had movements for the disabled, you had organized movements for militants, which were getting some kind of attention and feedback at the time. So there was this kind of wave, a little bit of optimism going through that, yes, and also an emphasis, perhaps an overemphasis as you look back on the fact that you could solve the problems by legal rights. I'm a firm believer in legal rights, but it's not enough. But the notion that you got the right to vote, and you got the right to desegregation and to some degrees, and so many of these other things could also, if you sat down and wrote out
Might that have been
rights.
because we had so many lawyers on the commission?
It might well. It might well have been. But I think there was that. Well, it was also called by many experts the decade of the rights revolution sort of thing. And I think that permeated it. The last thing I'm going to say is when you talk about maybe things we didn't fully understand or fully deal with, and certainly in D.C., I think in some ways the D.C. Crime Commission report, which we're not going to go into any great detail here, had to have and did have a slightly higher recognition of the insidiousness of the race problem in all of the criminal justice institutions. I mean, when they described, they did a survey of all the adult felons in D.C. in 1964 and 1965, and they came up with that the typical adult felon was a 24 to 30-year-old black man with no job or who had earned less than $3,000 in the previous year, few, if any, dependents, 40% addicted, 40% of them were addicts, et cetera. But I think that perhaps the flavor of the National Crime Commission report, which has been called a communitarian report, saying, you know, the most important thing we can do to stop crime, their overall notion was provide the opportunities for every American to attain his, full potential. That's the biggest thing we can do, possibly, to do crime. There was this feeling that there was enough goodwill in the country so that everybody wanted everybody else to get to where they should. And if we just came up with the right schemata, they would be able to. And I'm not sure we really recognized, the insidiousness of a century, 2 centuries coming out of our whole slavery background and how that had permeated our institutions. And it wasn't going to be sufficient necessarily, to write the laws differently. Okay.
There may be one other reason why the president appointed a D.C. Crime Commission. We don't have a lot of home rule these days, but back then we didn't have any.
True.
That's
So the president was responsible for crime in the district as much as anybody else was, and so that may partially explain what happened and
Yeah,
why.
good point.
We're going to shift a little bit now, talk about some of the broad recommendations, and I've asked each person here on the panel to talk about an area in which they had particular interest, and Susan Shapiro is going to talk about the notion that the best way to deal with the crime problem was prevention, deal with the problem on the front end. And what were the thoughts back then? What did you recommend, and how have we done on that?
It's complicated, and some of us are stubborn. It was great to hear Chief Judge Sarris's emphasis on prevention and on poverty, because, of course, nothing, at least in terms, and I think largely in belief, because we were an awfully optimistic bunch, nothing really was more central or more basic to the Crime Commission's approach and to the report. As you have certainly gathered by now, the Crime Commission was a big, bold venture with a can-do attitude. An early example for us staffers of that was that even before the work began, the word was out that we were going to do our job in the time originally provided. We were not going to ask for an extension, as so many such groups tend to do. And along with that can-do attitude was the resolute, determined optimism that you have heard about again and again this afternoon. We had an opportunity, and we were going to make the very most and the very best of it that we possibly could. And this is obviously reflected in the breadth and variety of the studies, the papers, the advisors, the consultants, the scope, the recommendations. This was the 60s. And as has been mentioned, things were far from calm. We had demonstrations, disruptions, and of course, crime in the street. But we also had civil rights legislation and a war on poverty. We had problems, and we were about solving them. Nowhere are this can-do attitude and this optimistic approach more evident than in the report's emphasis on prevention. Let me read to you briefly from the report. In the last analysis, the most promising and so the most important method of dealing with crime is by preventing it, by ameliorating the conditions of life that drive people to commit crimes and that undermine the restraining rules and institutions erected by society against antisocial conduct. The Commission doubts that even a vastly improved criminal justice system can substantially reduce crime if society fails to make it possible for each of its citizens to feel a personal stake in it, in the good life that it can provide, and in the law and order that are prerequisite to such a life. The sense of stake, of something that can be gained or lost can come only through real opportunity for full participation in society's life and growth. It is ensuring opportunity that is the basic goal of prevention programs." End of quote. This statement appears relatively early in the report. Toward the end of the report, the point comes, as it were, full circle, or perhaps acquires its other half. Again, quoting, "Given enough time and money, specialists can do dramatic things. They can prolong human life. They can make deserts bloom. They can split the atom. They can put men on the moon. However, specialists alone cannot control crime. Crime is a social problem that is interwoven with almost every aspect of American life. Controlling it involves changing the way schools are run and classes taught, the way cities are planned and houses are built, the way businesses are managed and workers are hired. Crime is a kind of human behavior. Controlling it means changing the minds and hearts of men. And surely we meant women too. Apparently not even the Crime Commission could be ahead of its time in everything. Controlling crime is the business of every American institution. Controlling crime is the business of every American." End of quote. In some ways, 50 years is a long time. A lot has happened. Many of the Commission's recommendations have been implemented or at least tried and experimented with. There's more training, more technology, more public defenders. We've got 911 everywhere, for goodness sake, an amazing achievement in our fractionated and turf-obsessed nation. But prevention can seem like a delicate and elusive goal, easy to put off or even give up on. Perhaps we can agree that despite the dedication and the downright heroic efforts of so many in the criminal justice field, prevention is not where we would like to see it. I would like nothing better than to be shown to be mistaken in this, but the contraindicators mount up. We have states trying numbers of young people, even very young ones, as adults, and numerous states without even a lower limit on the age at which a juvenile can be transferred to adult court. We have juveniles spending significant time in adult lockups and even in adult prisons. We have continuing and even intensified division and divisiveness along racial, ethnic, and religious lines, resegregated schools, enduring patterns of housing and neighborhood separation, alarming unemployment rates in some communities. We have increased law enforcement presence in some schools, high dropout rates, and widespread use of school suspension and other harsh sanctions without due process or recourse, generating concern about a school-to-prison pipeline. We have use of militaristic-looking police equipment in neighborhoods already distrustful and suspicious. These issues are complex and some may be controversial. People seeking the same goals may disagree about the best path. And prevention is never an easy sell. When crime seems especially violent and especially prevalent, even if it is a relatively few dramatic incidents that are making headlines, it is punishment that the public demands, that legislators vote for, and that is given perennially too limited crime-fighting dollars. In periods of less concern about crime, monies allocated to the criminal justice system may become even scarcer, and again, prevention may take a back seat. Indeed, it is rather remarkable, looking back, that a commission called in response to a crime surge should have spoken as ours did about the primacy of prevention. Today we have, it appears, less crime overall, but still tragic and troubling activities and levels in some areas, much of it involving young people and gang violence. At the same time, we see the stubborn persistence of the individual and societal ills the Commission talked about in making its case for prevention. How about bringing the spotlight to the whole idea of prevention, along with the many other critical aspects of the system, in the hope both of enhancing the security of all and of improving the lives of the many who remain on the fringes of our society? Of course, every next initiative is entitled to its own assessment and its own point of view. But I'm hoping that in this area, at least, the next initiative will pick up on prevention where we left off.
Thank you. Sheldon, to the non-controversial subject of policing.
Police,
Then
right.
and now.
Well, there's certainly a lot of controversy even today about police, as we know. But the description of what the police are like today in comparison with what they were like 50 years ago is pretty remarkable, and I just want to talk briefly about that. At the time of the President's Crime Commission, as I mentioned earlier, policing in America was at a pretty primitive state. Police departments literally had, or members of police departments, very little education, there was little training, there was little diversity, there was an enormous amount of brutality. You may remember the 1960s were the Warren Court era, where there was an effort finally to put some constitutional safeguards on things like brutality in terms of getting confessions. So it is really significant to remember that that was the state of policing just 50 years ago. And aside from the fact that there was little training, little in terms of educational standards, the structure of police at that time, which was basically akin to a military model, but there was virtually no oversight of police activities, either internally within a police department or externally. And there was certainly a schism then, as there is today, about the relationship of police to minority communities. So the commission, to its credit, focused a lot of attention at that time to certain basic principles. One is you had to elevate the quality of police personnel. A lot of recommendations on both education standards and the need for training. There was a lot of focus on oversight, a recognition that police officers on the street had enormous discretion, and there were really no policies in place to control that discretion. And there was, maybe even more than any other area, the need to establish clear relationships between the police and the communities they serve. A lot of focus on what ultimately became community policing. The genesis of community policing was the Crime Commission and the recommendations there. So I would say that this is one area, and there are many others I can think about that we may talk about later, in which the commission, as of that time, was quite intuitive about the importance of police in society and the reforms that were needed. And the other interesting thing was there were few dissents within the commission on various aspects of the report, but there was one dissent by 4 members of the commission who felt that because of Miranda, which had been decided again just before the commission was created, there were 4 members of the commission, including Lewis Powell, who felt very strongly that we were going too far in trying to apply constitutional principles in areas like confessions, and that the commission should have addressed that and restored the balance. And it was interesting to note that the commission decided not to go there at all, so all we had was the dissenting opinions. But again, in the 1960s, again, primitive state, and again, to the commission's credit, it established a blueprint for what should be done about policing in America, and I think it was a fairly good blueprint.
As I recall, one of the other points of emphasis was the need to increase the pay and the education levels of police. Did they say anything about more women and more minorities?
Yes, there was a lot of focus on the need for diversity, but it was not gender diversity. It was racial diversity.
One sort of footnote about your remark about the commission avoiding the police house interrogation is, interestingly enough, Jim Vorenberg, who was your executive director, had been the rapporteur for the ALI during that period when they put out, and Susan may know more about this, when they put out their draft model for police interrogation. But that was pre-Miranda. It did not go as far as the court went. Another interesting facet of that whole period was that Thurgood Marshall, before he went on to the Supreme Court, had been the Solicitor General. And I had the privilege of watching him argue in the Supreme Court. In the Miranda case, he argued against the position the court eventually took of having an absolute right of it. So, lots was going on in that period.
And of course, the ALI is back at it again on their police. They have a policing practice program. So while there's been progress, there's certainly things that need to.
Right.
The last thing I'd mention too is that there is a fair amount of attention now being given to the concept, and some research, not enough, perhaps, on the whole notion of implicit bias in police. And I had the privilege of reading a couple of the articles because my daughter does a lot of speaking on this issue. And that, I think, is just kind of,
Well, something when we get to the stage of talking about can you replicate crime commissions today to accomplish what we tried to accomplish 50 years ago. And one of the things we can talk about is Obama's creation of the Task Force on 21st Century Policing and the parallel between the recommendations of just a year or so ago and what we recommended 50 years ago.
Judge Wald, do you want to talk a little bit about alternatives to incarceration that we're talking about back then and how we're doing?
I'm cognizant of Judge Sarris's comments in the course of her very interesting and comprehensive speech about, which I took as a caution about alternatives, at least as far as judges were concerned. But the commission did call for a far broader range of alternatives for dealing with offenders based on, and I quote, that while there are some who must be completely segregated from society, there are many instances in which segregation does more harm than good, and concentrating resources of police courts and corrections on a smaller number who need incarceration will make it possible to give all offenders more effective treatment. The commission then went on to discuss three particular examples of what it thought would be very beneficial types of alternatives to incarceration. One was a youth service bureau, which would take all troubled youth and look and see whether or not counseling or better education or family intervention or whatever would be given so that they would not have to go through the juvenile court route. Another one they discussed was an experiment going on in California, which took one group of defendants and gave them intense supervision as opposed to a group that went to jail and prison and then found out at the end that indeed the group that had been given intense supervision did better. Their third example, which was particularly enticing, but has never come into being, is a, quote, an entirely new kind of corrections institution, close to population centers, containing as few as 50 people, and serving as a focus for community programs and a port of reentry for those coming out of prison. There may be one or two such institutions
Halfway
in the United
houses?
States.
You think they're halfway, they talk about halfway houses there, or?
No, I think they were talking about a whole new kind of community-based correctional institution, which became a community center.
Yeah, where people could be near families.
Somewhat followed corrections over the years, more from afar than as a participant, but you know, I just have not seen that come and be.
How about the others? Similarly?
Well, I did not conduct my personal survey. I can't tell you how many, but I will tell you this. My general impression is that you have had some model projects in particular cities, but that the notion of any of those three particular examples, or even of a wide array of alternatives changing the field has not happened. It's one thing, and we've only seen, in terms of reform, it's very rarely, but that a reform can change the entire field. It happens sometimes in medicine and sometimes in other things. Everything changes. The other is what I think we've seen here is you do have good-hearted people and progressive mayors or progressive police departments which will conduct some of these projects, but they haven't changed the basic institution. The DC Crime Commission, in one of its surveys, found that the majority of adult felons in the District of Columbia pleaded guilty, and 2/3 went to prison. It's not, you know, it's not that different across the board, but, because just to quote a few statistics, and I hope I won't repeat Judge Sarris's, is that the crime rate overall, of course, has gone down since 1967, despite the recent uptake in a few cities. But it's still lower, far lower than 1967 for violent crimes. But the incarceration rate, of course, has gone up by a factor of 6, now at 40 million. The percentage of minorities, mostly led by African Americans, but Hispanics to a great degree too, has gone up also by a factor of 6. So it's for blacks, it's 40% of the prison population. The rate of juvenile court defendants has gone up 300% since the 60s, attributed to guns, gangs, and drugs, but yet a vast majority of juveniles don't recidivate. In fact, there's some statistics brought out by the ALI is actually only 8% of the kids who appear in juvenile court actually come back and recidivate. But still, as Susan pointed out, and it's true, you still have thousands, 10,000s in one survey of kids being held in adult jails, and all we need is the recent exposés of what happens to juveniles on Rikers Island to show you, you know, how. Now, in the intervening period, too, that judges, as was pointed out, the mandatory minimums, I have to say that I sat on the appellate court, and we passed on cases that came up under the sentencing guidelines from the time they went into effect in the late 80s through the time after I had left the court in the year 2000, when they became, under Supreme Court decisions, to be advisory. Most of the judges I knew hated those guidelines. We felt that this is long before an enlightened sentencing commission may have made some good changes, but during the period that I was there, we felt our discretion was, I mean, some of this, I remember Justice Stevens dissented very eloquently, and the thing that got me was some of the guidelines had things in them, they were mandatory things in them, like in criminal records you had to take account of acquittals, and you had to take account of cases that were never proved inside those. And I once had a case which the New York Times picked up, the family guidelines were so strict that there was a mother who had 3 or 4 children, and she was basically a mule in the sense that her guy was, she was carrying drugs for him. So when the sentencing came, the sentencing judge down below tried to take into account that somehow that she could be based in a community program or something so that she'd have some way to relate to her children. And no. It was not in the heartland. The guidelines said, no, it was not in the heartland. There was always that phrase, the heartland of the sentences, that kind of deviation could come about for these families. And I remember questioning the DA who was arguing it, and I said, well, what's happening to those children? He looked, and he could account for 3, but nobody knew where the 4th child even was. So anyway, there's a lot of the judges, and I felt too, that their sentencing discretion had been far too strictly confined by the guidelines. And I read one account, and it said that even after the Supreme Court said that you didn't have to do that anymore, that basically something like 80 or 90% of the federal sentences stayed within the old guideline reaches. Okay, I'll get off of that anyway. My pointing out that I don't think the future is entirely bleak in terms of the fact that I think that sentencing, that the Crime Commission was onto the right tack in suggesting alternatives, but I agree that they should be evidence-based, and we should be sure that there's some good chance that they're going to work. But I do want to point out that the feds, we're going to have to look to the states. That's my big point. We're going to have to look to the states. Certainly, presently, the feds, if the Justice Department is any example, are not going to take the lead on any of this, on either getting away with mandatory minimums. But I also dealt with the Bureau of Prisons on behalf of an organization that was worried about women prisoners for several years. And that's why I almost had a laugh when I went back and read the thing about the institutions with 40 people. In the case of women prisoners, it's been almost an outrage because what do? They build huge institutions for women prisoners, and because they're a minority, they're brought from all over the country to those huge prisons. And where are the huge prisons built? They're built usually in the homeland of the home state of one of the members of the appropriations committees. And that recently,
Jobs program.
Yes, jobs program. Recently happened when they built a huge one down in Alabama, and then had to find women from all over the country. And this raised enough of a stir so that we did get the Northeast women protected through.
And of course, they're separated from their children.
Yes, that's the whole point. And I remember talking to the BOP. We met with BOP again. They've been terrible. They should be the flagship, but they've been awful. Not just for women, but in this sense, they've been cowardly, in my view, in terms of ever wanting to take on any kind of new innovative program. They're scared stiff of the prosecutors in the Justice Department. And so, all right, I'll end on a high note by saying that I think that there's a possibility of some of the overall rightness of the Crime Commission's notion that we do need alternatives happening, but it's going to happen, as Judge Soros pointed out, in the states, and it's probably going to happen because of economic conditions. They can't afford these great big horrible institutions. So they're going to be more adept at this. And I'm concluding with just a quick plaudit for the ALI's recently passed model penal code revision, in which talk about the Crime Commission, the length of theirs. This is another 350 pages based on sentencing alone, or based on sentencing and some, and what it does, and it is based upon the experience of state programs, probably one of the best compendiums of techniques, alternative techniques that have worked. So I'm just going to hit 3 of them and then I'll be done. The most critical thing, I think, is that it lays out guidelines and criteria for individual judges' sentencing versus the Sentencing Commission. It does accept, despite the fact that sentencing commissions at various stages in their development, the federal ones, states have been controversial as to whether they really do increase the likelihood of incarceration or they take away from it. But the notion of the Sentencing Commission in the Model Penal Code revision is that it will set ranges within which the individual can do, but the important thing is that the sentencing for imprisonment can be, it's happen only for a couple of reasons, which are laid out. And those are, the individual cannot be trusted to be put out in the public because individually there's a high likelihood that he's going to recommit the crime, or the crime is of such a gravity that you simply can't, it just would deplore the gravity of it if it got any less than sentencing. The third is the individual harm or the harm to the community in the case of economic crimes. But here's the important thing, and the overall notion is to get proportionality of the sentence to the gravity of the crime. We had a huge fight about this in the ALI. General deterrence is not a valid criteria for sentencing by the judge. The sentencing commissions can take general deterrence into effect in setting ranges, but the individual judge cannot say, because this is where most of the high sentences have come from individual judges deciding in their individual view whether you needed a general deterrence to this kind of thing. And this has turned out to be a very heavy factor in sentencing, and that's disallowed. Large amounts of discretion are given to the judges to work within the ranges set by the sentencing guidelines. They're not nearly as absolutely strict as were the guidelines, at least the ones under which I operated when I was on the court. Another thing, sentencing judges can take collateral consequences into account. I think we found out that many of that actually collateral consequences, you can't get a license for this, or you can't do this, or you can't do that. They turn out to be really a part of the sentence, in truth.
That's a nice lead into Betsy, because that's the part of the
I know. I know, but I won't say anything more about it. I just want to point out that part. The other thing, and give me 1 more minute, and I'll be done. The second chance is in there, and the second chance provision, which some states have already adopted, actually, is that after, I think it's 10 years, on the prisoner's initiative, not needing the corrections department's approval, on the prisoner's initiative, they can go back under conditions laid down and ask the judge, or a judge, if it's the same judge is not around, to modify the court sentence. And some states this turned out to be okay, and it works. There are provisions for deferred prosecution and deferred adjudications, and I realize that there are some questions, and Judge Saris alluded to some, but actually the way the code lays them out, there's enough specificity, I think, that might alleviate her concerns. Deferred prosecutions, deferred adjudications, there's provision for optionally drug courts, community courts, family courts, various things. A greater use of juvenile courts and resources, and much stricter conditions on waivers, because a lot of these kids have been waived to adult court on there. And finally, that many people go to jail simply because of the collection, simply because they can't pay the fines or the assessments of costs to them, or other factors which keep people in jail, including the bail, of course, for pretrial. So final thing is, there's no lack of ideas or models, but the resources may well be a problem. Still, our best hope is that states, for these economic reasons, will adopt more of these techniques, devoting sufficient resources to letting them work, and the Commission's overall aim might have some chance of coming into being.
Let's see.
I'll be super fast, but aren't we almost out of time? Or?
Yes, but I want to let you get your comment.
But in the interest of the audience, I'll try to be really speedy here. So, big picture. We had a lot of good ideas. You heard some of these from my fellow panelists here. All good people should think we had a bunch of good ideas. Did we totally fail? I mean, my sense is that if you look at the last 50 years, there's been a rather significant rejection of really the major thrust of all that we did. Okay, so yes, there were some of our recommendations got accepted here and there, but overall the thrust was rejected. If you had sat us down as a staff and said to us, in 50 years, there will be a massive increase in the number of people incarcerated, and we will not be rehabilitating those people. We will be keeping them there for incredibly long times and turning them out without having done anything enabling them to fit into society. That is not what we were out to do, okay? So did we utterly fail? No. Some of those ideas are alive today, and there have been some improvements. But there has been a very significant rejection, which to me means not that all crime commissions are hopeless. It means actually we probably do need another crime commission, and because we are in a terrible state today, I think. In some ways a different kind of terrible state than what we faced 50 years ago, but the mass incarceration picture is horrific. The economic inequality picture, we have not done prevention. Economic inequality is way worse than it was 50 years ago. So very briefly, in terms of some of the particular work I did have to do with collateral consequences of being convicted. And as this young, naive creature, I was asked to look into some correctional issues. I started discovering collateral consequences and was horrified to discover that at that time there were all sorts of mandated disabilities. People once convicted might be denied the right to vote forever, might be denied all kinds of licenses, employment-related licenses forever. Things they might, if they were lucky, get trained for in prison, like learning to cut hair. You get out and discover you can't get a barber's license. So deeply irrational in many ways. Irrational, I mean cruel, inhumane, creating an outcast class who came out of prison and were then unable to figure out how to do anything to get in the mainstream, but deeply irrational from the point of view of society, because of course most people were going to come out, and then if you didn't give them a way to get into the mainstream, and particularly to get employed, what options did they have other than to do the things that got them into prison in the first place? So it seemed to me lunatic, and I wrote a chapter attacking these things for the Corrections Task Force. And so what's happened since? I mean, I think as Judge Sarris's talk indicated, and as all my fellow panelists have indicated, there's some advances. There's some improvement. So I did reread my chapter, and I have followed up in the law in the area of collateral consequences, because one of the things writing my chapter did in terms of my own life was inspire me some 5 to 6 years later to start a public interest law firm, which still exists, called the Legal Action Center, which is initially focused on addressing the collateral consequences of conviction and trying to break down barriers, particularly to employment for ex-offenders. We expanded the work almost immediately to cover people dealing with substance abuse, because these two populations are more or less the same, the drug offender and the criminal offender populations. So legal action exists and does good work. I'd like to think that that's one positive development in some ways as a result of writing that chapter. There have been a lot of positive changes in the law, whether that's in any way a result of the Crime Commission's work or just would have happened anyway. It's always hard to know, but there certainly are less state laws and regulations that limit right to vote, right to employment. There are a handful more new laws that actually prohibit discrimination based on offender status. There's an important federal law, American ADA, Americans, I can't even think of it. Disability Act, which I teach, American Disabilities Act, which provides interesting new protection for people with drug histories in terms of employment, to the degree it hasn't been hopelessly gutted by the Supreme Court, but it still has made a difference so far. However, despite these improvements, if you have to look overall at the picture of collateral consequences, what do we have? By virtue of having massively expanded the number of people who are arrested, convicted, and imprisoned, even though the consequences of being imprisoned aren't as bad as they used to be, it's way worse overall in terms of the total problem, because we've got so many people who are now suffering not only incarceration, but discrimination as a result of incarceration. And yeah, there's some limited legal protection, but doesn't count for much. You've got employers who, if they've got the choice between people who've been incarcerated and people who haven't, who might discriminate. So unless you've got good laws, and we don't have them as of now, protecting against that kind of discrimination, these people are going to suffer discrimination. And even when you've got good laws, we've now got technology that gives employers the ability to kind of bypass laws and find out if people have been arrested and convicted. So it's a mixed picture. And I think we have to think about not the details of all our great ideas, but what to do now. Because the fact is, we had a bunch of good ideas. Mostly society has rejected everything that we set out to do. It accepted a bunch of specifics, but in terms of the overall picture, I would say it's way worse given our overall goals, which were prevention, which were rehabilitation, which were diversion from the criminal system for those who could be safely diverted. And it's not a pretty picture today. So what's encouraging, I think, is that there is new consciousness now on, to some degree, both left and right, Democrat, Republican. I think the mass incarceration, the economic expenses of that have gotten to a lot of people, as well as the social expenses of that. And in terms of the particular issues I worked on, collateral consequences, there was no recognition when I was writing that chapter. There was practically nothing out there that I could look to say, oh, I can cite this and say, otherwise people have thought this is a bad thing. But there's a lot of recognition now of what's often labeled sort of reentry issues, that we should have reentry for people who have suffered arrests, convictions, and increasing recognition that the drug abuser population deserves that kind of rehabilitation and reentry also. So, there's new consciousness, there's some new readiness, I think, for sympathy for many of the ideas that we were promoting 50 years ago. But something new has to happen to make for a world that I think we were right then to think we should have.
So we're out of time, but I promised there's going to be one final round of 1 minute each, in which the proposition is as follows. There's a proposal in Congress to have a new crime commission Good idea or bad idea, and one good piece of advice if they go ahead with it. Susan, can we begin with you?
First of all, crime commissions don't exist in a vacuum. And while it would have been inappropriate for the crime commission to take full credit, even if a lot of its recommendations had been adopted, it probably is somewhat unfair to the crime commission to say that it was a failure because its recommendations were not adopted. Times change, and especially politics change. And my question about a new crime commission is, what is the impetus for it now in terms of what people want to accomplish and why they want to accomplish it? And what would it look like? Our crime commission was a pretty broad group of people. It had enormous cooperation across the government and the private sector from all sorts of people. It couldn't have done what it did without that kind of cooperation and buy-in. We keep hearing and seeing that we live in a very different time now. What would a crime commission look like? How would it operate? What would it be trying to accomplish?
Betsy?
Totally depends who appoints this commission and what their motivation is. So if it is President Trump and Attorney General Sessions Crime Commission, I would much rather not have one. If it's a completely differently oriented commission, yes, I think it would be a good thing to have one.
Sheldon?
Well, first of all, I want to close with an optimistic note about the President's Crime Commission 50 years ago. I happen to think that there were some very positive things that came out of it, and it's to a certain extent why we're here talking about a commission that's 50 years old. It had a dramatic impact on research. It had a dramatic impact on increasing federal support. And I certainly agree that there have been a lot of failures. But ironically, the most successful aspect, I think, of the commission 50 years ago was the improvement in policing that I described before. I think there clearly is a need for a lot more work in police, which is why there was a task force, the Obama task force. I would be opposed to a commission if Congress had anything at all to do with it. I mean, the reason that the President's Crime Commission was enlightened was because it was appointed by a president who looked for an impartial group of people. And there's a great deference and reliance on a very good staff. And a recognition that it would be important at a particular time to focus on the merits rather than on political ideology. And I just don't think we have the opportunity right now to address those concerns.
Good, you got the final word.
Okay, I'm very dubious about a crime commission, a governmentally sponsored crime commission at the present time. See me after the next election, and I might feel feel differently. But I point out that although the 1967 commission was indeed bipartisan, if you look at the names, every one of those, Republican or Democrat, was a moderate. And we did have moderate Republicans there. You didn't really have any that I would have considered, and it was true of our commission too, who were extremes, represented the extreme views about going back to the days of law and order, et cetera, which we do see very prominent in the current discussion. So I wouldn't like to see that perpetuate or become almost a good housekeeping seal of approval on some of the very things that the 1967 commission would have felt abhorrent about. I would suggest that rather than even a crime commission, what I would love to see somebody at the appropriate time put together is a compendium of how you do some of these reforms politically. I mean, how you get over the obstacles, the practical obstacles that have probably stood in the way resource-wise and political-wise with these. My final notion is, I think after 50 years of at least think being on the edges of several aspects of the criminal justice system, I think that the biggest problem, and it's one that goes toward attitudinal research sort of thing more than perhaps the legal research, is how do you give the people who have control over others' lives, such as we give to the participants in the criminal justice process, enough discretion to do the right thing, but with a control of those discretions so that they don't go amok.
It seems like an appropriate question on which to end the program. I want to thank our panelists and for our patient audience, and I think we are now
audience.
set to be adjourned.
Yes, we can do a round of applause. I just want to very briefly thank our participants tonight very much, and Dean Morrison for moderating the panel, and say that while this sort of closes the chapter on where we've been, we look forward to all of you joining us tomorrow morning to discuss further where we're going to go with this incredible setup. So we will reconvene at 8 a.m. tomorrow morning for breakfast, with a session starting at 8:45, and we look forward to seeing you there. Thank you again.